Well, thank you so much for joining us today. My name is Ana Paulina Gomez, and I'll be the moderator today for this Launch and Learn that is sponsored by the Government Lawyers Committee and the Civility in the Profession Committee. It is my honor to introduce you to our wonderful speaker, Ann John, who practices law in Fayette County. She was PBA president from 2019 to 2020. Among her initiatives as president, she created the Committee on Civility in the Profession, which I think it is so important, especially now. And she continues her service to the bar and the community, and she is a frequent CLE presenter and planner for the PBI and other CLE providers. Today, we will be talking about a practical approach to civility for government lawyers. We encourage you to participate and share your thoughts and experiences. We believe that we will get more out of it if we hear from everyone that is attending this Launch and Learn. Please feel free to raise your hand if you have any comments or questions, or you can also use the chat option. So now, without further delay, I will turn it over to Ann.
Thank you so much, Ana Paulina. This is an honor for me to be here with your committee. And thank you, many thanks to you and to Dana for putting this together. Since you mentioned my presidency and my initiatives, I am going to take just a moment to make a brief plug for the Committee on Civility in the Profession. That was one of my initiatives. I created it, and it has taken off tremendously. It does tremendous work. It's under the current leadership of two phenomenal leaders, Judge Cheryl Austin and Michael Pierce. And of course, Victoria White, I can't say enough good things about her. I saw earlier that she's on here today. And I welcome, Victoria, we welcome your input as well. So please join us in that committee. It is open to everyone in the Bar Association, and we would love to see all of the members of the Government Lawyers Committee join us. So that's my plug for the day. So when Dana and Ana Paulina first approached me about this lunchtime session, my initial thought was, well, I'm a private practitioner. I'm not a government lawyer. How could I possibly be of any assistance in this lunchtime session? And after talking to them, I realized that as government lawyers, your client, of course, is the Commonwealth of Pennsylvania. And as you serve your client, all of us practitioners have dealings in one way or another that is impacted by your service. So civility on both sides of that table is very important to our clients, the Commonwealth as a whole, and to the general public. And that's really where we begin this is, how do the members of the public perceive the Commonwealth agency? And I will tell you, when we ask these questions, we are looking for audience participation. So please jump in at any time with questions, comments, answers, and feel free to interrupt. So we are civil here today, so interruptions are welcome by me anyway. So let's start with that question. How do members of the public perceive the Commonwealth agency? Any thoughts? Okay, we can come back to that because we have some question and answer ideas later on in the session. And Suzanne looks like she wants to speak.
So Anne, I was a former public defender, which is a government agency, and I routinely was told that if I was nice to the DA, I must be working with them in order to get my client not a good deal or convicted. And so I can't speak from the side of the DA, but from the side of the defense attorney. And I try to explain that, the goal is to get them a good result, which means I should be nice to the other side, not be a jerk, because that wasn't going to get me a good resolution. But that was a typical, if a client saw me interact nicely with the DA, and routinely we both worked in the same government building, and we declined to ride with each other because we didn't want people to see us arriving together, because that would look bad for both of us.
And Suzanne, you raise an excellent point there. There is a very clear line between acting civilly and acting in a courteous manner and crossing over to improper behavior. And I'm glad you point that out. One of the things that we talk about is the intersection of the rules of civility and the rules of professional conduct. The Code of Civility, and I said rules, they aren't rules. It is a code. And if we look at the next slide, that intersection between the Code of Civility and the rules of professional conduct is very interesting, because as we'll see on the next slide, the Code of Civility is aspirational. It is something that we as attorneys aspire to. And as we all know, the rules of professional conduct, of course, are mandatory. So how do those two manners of behavior impact what we do? We first have to look to the rules of professional conduct, because we need to be certain that we are complying with those rules that set out the minimum ethical standards for the practice of law. And that is right from the disciplinary board's website. They constitute a set of rules that all attorneys must follow. So since their promulgation in 1988, all of us have been mandated to comply with those rules. And if we look to the preamble of the rules of professional conduct, we'll see language that there is a general orientation and that we need to act zealously. But what is zealous? You can be a zealous advocate for your client. And for government lawyers, it is the Commonwealth, as we know. But you can be zealous and at the same time be courteous. And if we go to the next slide, we'll see that as an advocate, a lawyer zealously asserts the client's position under the rules of the adversary system. And then if we go on, we'll see that we can do that in a manner that is still civil. We should be guided by the basic principles that include the lawyer's obligation to zealously protect and pursue a client's legitimate interests within the bounds of the law, while maintaining a professional, courteous, and civil attitude toward all persons involved in the legal system. And that's where you also see an intersection, because the aspirational Code of Civility, which was promulgated in the year 2000 and amended in 2005, the aspirational Code of Civility does set forth in the article dealing with lawyers that a lawyer should act in a manner that's consistent, fair, with a fair, efficient system of justice, and treats all of the participants in a professional and courteous manner at all times. The principles apply to the lawyer's conduct in the courtroom, in office practice, and of course, in the course of litigation. So let's take a look at how we put the code, these aspirational goals, and the rules, the mandatory rules. How do we put them into practice? So one of the first things you want to do, and this particular slide may or may not be as relevant as some of the other things we'll discuss, because this is geared toward taking calls. And I know that many of you aren't dealing with the public directly, but to the extent that you are supervising those who may be dealing with the public, in that capacity, you want to be mindful of who is calling and asking for the information. Is it a member of public who is just looking for someone to listen? Is it someone who is just frustrated and just wants to say, hey, I'm here. Can you help me? So when you're supervising those calls, when you're looking at how to deal with them, you want to look at them from the other person's perspective. So let's look at the next slide and try to see what sorts of roles we may be perceiving. So a member of the public might view an agency as an enforcer. But as counsel, you understand the role of the agency with respect to representing your client. So that member of the public, when they call, they may be calling with questions that don't have a clear answer. They may be calling just to be heard, as we discussed. But when you're dealing with counsel, of course, hopefully you're trying to resolve a case and work it out. And we each have our goal, which is to help our client and advocate for them and to receive and obtain a just result. So what is civility? Let's look at what civility is. If you know your audience, you can tailor your response to them. And, it doesn't hurt to say, how are you today? How's your day going? Of the attendees today, have you had situations where an opposing counsel calls the agency, isn't familiar with the process, and reaches out to you as counsel for the agency? Have you had those situations come up? I see at least one head nodding. So how do you deal with that when someone calls in and says, look, I'm not familiar with the process, but I have a client who needs XYZ. Can you help me? How do you deal with that situation? Any takers out there?
This is Dana. I know, like, at the Department of State, we're prohibited from providing legal advice. So it gets extra tricky when an attorney calls and wants legal advice so that they can give their client legal advice. But I always try to be as helpful as possible because it just is so much smoother. And I, try to find a way to give a background or information about the process so that they understand it versus telling them like how to advise their client.
And any others? I can't see hands because
it is hard to see hands, but please feel free to jump in if you would like to add anything to the conversation. I agree with Dana. If an attorney calls and they start asking questions, I think it is our responsibility as government attorneys as try to be as helpful as we can without crossing that line of at what point is it giving legal advice, which we cannot do. And usually what I do in those situations is saying, I'll be more than happy to explain to you the process. However, I cannot give you any legal advice, and we can just go from there. But I do believe that whenever you have an attorney who may not be familiar with your agency, the more information you give them, the easier that maybe you can solve an issue that they have.
And Anna Paulina, you raise an excellent point. The old knowledge is power. Once you know something and understand it, you're more willing to deal with it in an efficient and civil manner. I think we've all experienced the individual who contacts us and doesn't really know the particulars, doesn't really have a grasp of what's going on. And when that happens, oh, here we are. Hi, everyone. When that happens, giving them the information that will not constitute legal advice. We all know that can't be done, but will assist them in understanding the situation better. And when you can do that, when you can help someone understand a situation, civility often follows, because civility is a means of, I get into it further into the slides, and I don't want to jump that far ahead, but there is a slide where I take a quote from Black's Law Dictionary that defines civility, and the final sentence of that definition is, it is the absence of rudeness. So, if we can create a void where rudeness would have been, and often it's knowledge and information that can fill that void. So again, I don't want to dominate this, but I would love to hear any thoughts from anyone in the audience, and especially I can now see the audience. I can see who's here. Although the Zoom is great too. The PowerPoint is great too. Ann Begler, your video is on. So from that, can I assume you would like to speak?
Always have my video on, but I didn't know we weren't supposed to.
Oh, no. It's great that it is. I welcome that. It's always great to see who you're speaking with and to.
So, and it makes me think, just in terms of my realm of work, that when we think about being zealous as attorneys, and I think as a government lawyer, it's maybe a little easier to have balance because you do have a responsibility to the larger public. But I think that to get to this end point, we can act quickly sometimes. And that's where I think that the work that we do around emotional intelligence and self-awareness becomes really important and helpful in this area, because we don't get lost in knowing about this commitment to be zealous, but we have time, if we practice, to reflect on, what do I notice about myself now? What might I say? Doesn't take that long, but having that self-reflection and awareness of what's going on with me helps me, I think, reach out more in a way that honors civility. So that's what stands out for me, just because of the different kinds of work I do.
Well, and everyone in the audience may not be aware of your type of work. Why don't if you wouldn't mind sharing that would be wonderful, Ann.
Well, I mean, I spent a long time, obviously, in mediation, alternative dispute resolution, but for the past 12 years, I've also been doing work as an executive coach, and a lot of the work is centered on emotional intelligence, but not mostly one-on-one coaching. But I just spent 10 years working for a major manufacturing company as an external person, doing internal conflict and coaching and a bunch of stuff. But that's just in my long-term background of Gestalt work and everything. It's just, I don't know. And clearly I'm somebody who can have an outburst, and I've had outbursts, but I do find that if I can be more self-reflective and help other people do that, I think I'm forming and have formed a different sense of myself and my capacity. And I think it's great for lawyers and other people.
And you hit on a wonderful point. And I think one of the slides coming up is to set the tone. And, you set the tone by maintaining control. You can set the emotional tone by being calm, cool, and collected. And the calm demeanor that you just described, it is contagious. So if as is the hysterical, the theatrical, though the demeanor that takes things too far, the demeanor that aggravates rather than alleviates, that demeanor is likewise
Mhm.
contagious.
Mhm.
So you're absolutely right, Anne. Thank you for sharing that.
In the field of EI, that this process is, what do I notice about myself right now? Where am I? What's going on? What are my choices? And what will I do? And it sounds laborious, I think, but I think once we can embody some of that, it's not really a laborious piece. It just becomes a little easier to pay attention before we jump. And I'm not professing that I never jump.
Well, you know, even if we don't all jump, we sometimes at least take long strides,
Yeah.
longer than they should be.
Yeah.
um, and you know, setting the tone by not trying not to jump, or if you jump, you know, you can always jump back.
Yeah.
And conciliatory words aren't a sign of weakness. You know, saying, "I'm so sorry, I lost my cool. I didn't mean to lose my cool." Those types of conciliatory words can go a very, very long way. Anna Paulina, you were nodding your head. Please jump in.
Yes, I agree with that. And I think, earlier in my career, I actually believed that if I showed any sign of kindness, that it was going to be seen as weakness. And I now, with more years as an attorney, I realize actually it does not.
Mhm.
And if someone takes that as weaknesses, honestly, it is on them, and it's going to be harder to get things done.
Yes, absolutely, absolutely. Civility does not equate to weakness. Civility absolutely is not a sign of weakness. In fact, it is a sign of strength, because number one, if you know your stuff, so to speak, if you do your work, do your homework, do your research, have the information, if you have that knowledge, then what follows from that is confidence. And when you have the confidence, then that confidence leads to a better understanding and the ability to be civil. You don't need to be rude or outrageous in order to make your point, because you are equipped with the knowledge that I know this stuff. I know this is how it goes.
And actually, the thing that is a great point, and I agree, the best attorneys that I've met, they are the ones that can keep their cool in tough circumstances. However, I've noticed that that it really also depends on the venue. If you are in county court, let's say central Pennsylvania, the tone is extremely different than if you go to Philadelphia. And I think sometimes you have to not lose your civility, but also try to get a clue of how the court operates and what they're used to. What would you have to say about that? Because I think it is a little bit difficult when you're used to a certain type of venue and then move to a different one, and you're like, okay, this is very different from what I'm used to.
Excellent point. Excellent, because that is part of doing your homework and doing your due diligence, so to speak. Research the venue. Where are you? Are you in the Court of Common Pleas of Philadelphia County? Are you in the Court of Common Pleas of Fayette County? Are you before a tribunal? All of that information will assist you in knowing how to prepare. And once you know how to prepare, you can act appropriately. Because, I don't mean to preach civility in the sense of be a doormat. No one should allow anyone to step on them. You have to have the confidence to be assertive enough to say, no, this is the way it needs to be, because section such and such of the regulation states as follows. And these are the regulations. period. So being civil does not equate to stepping aside and saying, okay, walk all over me. So you're absolutely right, Anna Paulina. Good point. Thank you. So this one again, is somebody calling in and you're supervising the person who takes the call. And again, it's looking at it from their perspective. Let's go on to, I think, is civility and electronic mail. Then there we go. And this is a big one. This is how so much communication takes place today. And I think we all know the proverbial, if you type in all caps, you're yelling at someone, right? We've all experienced the capitalized email, and even less forthright, even more subtle means of conveying that anger, or even the means of conveying the anger by just shooting out a quick, "You are absolutely wrong," email, something like that. What you need to step back and consider is, how can I distance myself from that angry email? You can be professional, and at the same time, you can respond appropriately. You can show respect and civility. And how do you do that? You do that by addressing Ms. Begler, as opposed to just shooting out an email and saying, "Hey, Ann, let's do XYZ." Or, "Hey, Dana, I disagree with 1, 2, 3. I think that unless you have that relationship already established, now, of course, many times you're corresponding with people with whom you already have an established relationship. But if it is a newer relationship, I don't think there's any harm in addressing the person as Mr. or Ms. or judge. Of course, you never want to address a judge as "Dear so-and-so." It has to be "Dear Your Honor" or Judge. I think that when you address someone more formally, it sets a tone of, this is someone who is showing me respect. So I will respond with respect. Anna Paulina, what are your thoughts on that with the salutations?
I agree with you completely. I think it is never a good idea to send an email when you are aggravated at someone, even if you are rightfully so frustrated because of the email.
Mm-hmm.
Because if you send that email right away, it will probably have a tone that you don't intend, and it will just make things worse.
Yeah, absolutely. That's why the final thought on this slide is, your draft folder is your friend. Because, and even though we don't express it that way in the slide, use your draft folder. So when you get that nastygram, then you don't respond. And one little trick that I've given myself is, if I get a nasty email that I have to say something, I will type an email without an addressee line. So the line where you would type in the address, the name of the recipient, is blank. That way there's no danger that you're going to accidentally send it to them. You don't want to type a reply and delete the recipient's name, because there's always the danger that you might have hit reply all by accident. And reply all is one of the most dangerous. I can see Dana smiling. Reply all is one of the scariest things out there. And so you want to just have no recipient at all in the email, and then it will go into your drafts folder. You don't have to worry about it. Similarly, you can schedule, and even with other forms of email, and Dana and Anna Paulina, I'm not sure how your email systems work. I use Outlook, but if your email system, okay, so you're both nodding, you can schedule. So there are all sorts of tips and tricks that you can use within the system. And I'm sure you've used them. So your draft folder is your friend. One of the things that we thought might be an interesting exercise today is to ask some multiple choice questions. And we have some very good scenarios later. Let me see, where are we? We're at 12:33. I think we have time for the multiple choice very quickly. Do you agree, Anna Paulina? We'll do those very quickly, and then we'll get to the scenarios that I think are very, very interesting. Okay, so John Q. Public calls the office for the third time today. No one can take the call. And the person that you're supervising comes to you and says, what do I do with this person? So do you tell them that the contact person's still unavailable, but we'll get back to him within 10 days or so? Do you tell him everyone's avoiding him because he whines too much? Do you ask him to call back after he's had some time to think about his demeanor and is ready to treat you with respect? Or do you tell them that you understand the frustration and you've been in those situations yourself, which, we all want to equate, we all want to feel like we're in the same boat. And you don't have an answer, but we're all going to try our best to resolve this. So what are the thoughts on this one?
So, number 4, obviously, is the nice answer. But I will say that if a client or potential client has been rude to staff, I will routinely say, it's been inappropriate. You cannot yell at my staff. Yes, you're frustrated, but my staff is my staff. And maybe 75% of the time they're apologetic and, they were frustrated. There are some that continue to yell, and I will tell them that if they can't be appropriate, that they should not call back until they can be appropriate with staff. Because my staff should never be treated badly. If somebody yells at me, I can handle it, but never my staff. Even if they've done something wrong, the client does not get to yell at the staff. So that's, but generally, we try and we, even difficult people will calm down if you at least say you understand their frustration. And if it's something that I can't help with, I'll try and send them on to somebody who maybe can.
Excellent. Thank you, Suzanne. Any other thoughts out there?
I was just going to say that.
Oh, go ahead. No, ahead, Dina.
No, I'm at the Department of State, so we have licensees that call in, and a lot of times, it would always seem like a Friday afternoon, like somebody would be so frustrated, or maybe they have mental health issues or are suffering from impairment, and they just want somebody to listen to them. So it's easy to dismiss, like if it's not something that's in my section. But I found that listening and being kind goes a long way.
And I think Suzanne made a really good point that if someone calls and they're being very rude to people in the office, I think it is also our obligation to say, hey, that is just not right. Mm-hmm. I know that you're upset, but the way you're treating people is just not okay.
Absolutely. Excellent. Thank you, Anna Paulina. Let's look at the next one. And this one is interesting because they're probably going to be calling you, because this is the lawyer who calls sobbing because they missed a deadline on behalf of their client, and they don't know what to do. No one can talk to them. Do you tell them that crying isn't going to get them out of it? Do you tell them that since the purpose of your agency is to serve the public, they should just quit calling and figure it out for themselves? Or do you listen to them as a professional courtesy and then patiently explain that, of course, you cannot give them advice. You can't give them any type of legal advice, but you understand that they have a concern. And what do you do then? Give their message to the appropriate person? Do you talk to them more? What are some thoughts on this one? Any thoughts?
Anyone?
Okay.
Dana, what would you do?
Well-
Not to put you on the spot, but
I try to be as accommodating as possible because you don't know when it's going to be the reverse situation and you miss a deadline and you want some courtesy, because there's nothing worse than that dread feeling in the bottom of your stomach when you miss something. So, I would probably I would go with number 3.
Yeah.
and I want to say, like, on the chat, people are answering as well. Jennifer Newman, she mentioned number 3 as well. So if you're too shy to say it out loud, you are free to use the chat as well. Thank you.
Well, this is Megan. I'm not on camera because I have no makeup on and I'm not subjecting anybody to that. But I work with Dana in the Department of State, and with a lot of licensing situations, there are opportunities that people can request reconsideration, or there are some workarounds with some of the deadlines. So, I think a lot of us will show courtesy and say, okay, well, you missed this, but maybe you can request reconsideration, or, your client could present, without giving them legal advice, just kind of suggesting some other avenues that they could take.
And Megan, thank you very much for that answer. It makes an excellent point. Gently tell them to look at the rules,
Right.
look at the regs, and maybe they can help themselves. And that way, there's no animosity in the situation.
Anne, hi, can you hear me? This is Victoria.
Hi, Victoria.
Hi. Well, another thing that you could tell them is to call the ethics hotline, because a lot of times lawyers miss deadlines. They miss and they make material mistakes, and there are certain ethical requirements you have to do if you do make a material mistake. And one of them is you have to communicate with the client. Got to tell the client that you made the mistake, and it could cause a conflict of interest for you, because on the one hand, your duty is to advocate on behalf of your client. On the other hand, you want to obviously defend yourself. So a lawyer who makes a material mistake or an error has a duty, number one, to communicate that to the client, then advise the client to secure independent counsel for a potential malpractice claim, and then put your carrier on notice.
And Victoria, that is excellent. Thank you so much for that information. You're absolutely right. And this is a good time to plug the ethics hotline, which Victoria is just astounding in her role in taking care of that hotline and responding to the ethics questions. And as you just heard, she has a command of the rules at her fingertips. She knows them like the back of her hand, and her assistance in that situation is invaluable, because the caller, the person calling in with the missed deadline, has certain obligations under the rules of professional conduct, and Victoria can assist them with finding the appropriate rule and how they can comply in the appropriate fashion. And it avoids a situation for those of you who are on the other end of the phone with that lawyer. So, Victoria, other thoughts on this?
No, it's just that, we have issued opinions about, what a lawyer's ethical obligations are when you make a material error. Sometimes the client doesn't want the lawyer to terminate the representation because they don't want to start over with an entirely new lawyer. So long as you believe you can provide competent and diligent representation to the client, and the client gives informed consent, then you can waive that personal interest conflict.
Thank you, Victoria. Perfect. So the answer is number 4.
Yeah.
Let's look at the next. Let's look at the next scenario, and that's an email that has all of the wrong things in it. And this goes to the question of, do I immediately reply with an admonition that they're not going to get a real answer until they clean up their act? Do you forward it? And that's an ethical question. Do you forward it? And Victoria's smiling. I'm gonna put you on the spot, Victoria, with this one. Or let's run through 3 and 4, and then I'll put you on the spot. Do you delete it and hope the sender forgets they ever sent it? Or do you reply with a very brief but unemotional response that their concern has been received? Or is the answer number 5, Victoria? So the frown emoji.
Not the frown emoji, Anne.
The frown emoji is not a good idea. Go ahead. I'm sorry.
No, I think when dealing with the public, because we're government lawyers and we're also lawyers, so we know that the public doesn't have a great view of the bench and the bar. So I think if you can take the higher road, respond in a neutral, professional manner, then they have nothing to complain about. Reply with a very brief but unemotional response. I don't know about unemotional, perhaps neutral and professional. Because you don't want them to feel as though they don't matter.
Yeah.
Well, I deal with this. This is Megan. I deal with this a lot. I'm counsel to the State Board of Nursing, and we have a lot of licensees that we suspend, and then a lot of licensees that come back and want to be reinstated. A lot of them are very upset and angry about the process. And I just forwarded to Dana somebody that was swearing at me the other week because they were mad about stuff. And I just continued on and sent them what they needed in order to reinstate their license, even though they said they didn't want to deal with me. I'm like, okay, I'm the one you got to deal with. Here's what you need to do. And, because, we get people that complain to their legislators. So I want to be able to provide evidence if needed that I handled myself professionally. I kind of look at it as customer service, that I want to treat them the way I want to be treated. And I know that people, aren't always nice, but I try to put myself in the position of, if I was trying to get my license back, I would hope that people would be nice to me. Now, of course, I wouldn't treat people the way that they're treating me often, but, I just kind of look at it that way, that we're serving the public, and it's basically what I'm stuck doing, is being nice to people, even when they're mean to me.
Thank you, Megan. Kayla has her hand up. Is that Kayla?
Yeah. So my name is Kayla. I actually work for the PUC, so I probably have a different perspective on this one because, we do a lot of cases that impact, customers. So like in my current position, if I were to receive an email like this, there's a good chance that I wouldn't be able to respond because it relates to like a docketed proceeding that's currently being litigated, and we can't, because of my position, we wouldn't be able to respond. So there's a good chance for this one, I would just have to ignore it, potentially report it to the Secretary's Bureau to go on the docket. So there's a couple different ways that this one may be handled, or depending on what they're complaining about, we have like an internal bureau that would look at customer complaints. So I think for this one, it kind of depends on your position and your agency and like what the complaint's about.
Excellent point. The first thing you do is look at the rules of professional conduct, and what do the rules require me to do ethically, and what does my position require me to do? Any other thoughts? Anna Paulina, you unmuted. So
yeah,
are you?
We have 10 minutes left.
We have what?
We have 13 minutes left.
Oh, so let's get to the next one is the one that I think is really interesting, and it is a situation that does occur and has occurred. So let's say you're at a hearing, the cross-examination has become very tense, and opposing counsel on the record calls you annoying. So and Victoria's smiling. I can't see everyone, but I'm sure many of us are smiling. That word has been used in conjunction with me many times. So I'm not even shy about admitting that.
Yes.
I will tell you very quickly that the Code of Civility, Article 2(5) says a lawyer should abstain from making disparaging personal remarks or engaging in acrimonious speech or conduct toward opposing counsel or any participants in the legal process, and shall treat everyone involved with fair consideration. So this one, I'm just going to put out there. What do you do? How do you handle it when someone on the record calls you annoying and it has to be addressed? What do you do?
And just with a caveat that the hearing examiner is just not doing anything.
Yes, excellent point, Anna Paulina. You know, do you deal with it yourself when the presiding officer, presiding judge, presiding hearing examiner is doing nothing about it? Do you just sit there and take it, so to speak? Thoughts, Anna Paulina?
Oh, I thought, Suzanne, do you want to say something?
Suzanne? Yes.
So
I didn't see Suzanne. I'm sorry.
That's okay. Being called annoying isn't really a big deal. I might, say something after the hearing or whatever, to address it. It's now when someone has accused me of something more serious, some kind of rule violation or something unethical, I do not let that sit. That I will address right away, because that's out there on the record and it can't be left without a response. But being called annoying, I might respond that I'm doing my job and moving forward. I think most of the judges in York County will usually remind the participants that they're to be addressing them, not the other attorney, if they have an objection, to make it clear and let the court handle it. And they will, I generally see them intervene if it's something that, is inappropriate. But being called annoying, I mean, that's not that bad. There's worse things I've been called.
I'm going to ask you to hold that thought till the next slide, because the next slide sort of touches on it. But before we jump to that slide, because that's you make good points, Suzanne, but I will tell you that if you also look at Article 2, numbers 12 and 13 of the code, and again, this is aspirational, it's not mandatory, but a lawyer when in the courtroom should make all remarks only to the judge and never to opposing counsel. When in the courtroom, a lawyer should refer to opposing counsel by surname preceded by the preferred title or the professional title of attorney or counselor. So, the code gives us guidance in that respect. So referring to opposing counsel as annoying is, I didn't see it anywhere in the code. It's certainly not part of that. But Anna Paulina, I'm sorry, go ahead.
So this has happened to me, and I'm not proud that I've responded in kind, which I should have just asked for a break. So I think, now with more years of experience, I think I would have handled the situation a little bit differently, because I do think that people are looking at you. The hearing examiner is looking at you. Your client is looking at you. Witnesses may be looking at you. And I think personally, requesting a break and just having a conversation with the hearing examiner, just to make sure that doesn't happen in the future, because it is distracting. It is on the record, is distracting. It's not relevant to the case.
How about asking for a break and having a conversation with opposing counsel outside of the courtroom?
I don't know if
How
that
about-
may escalate things.
Any thoughts on that? Suzanne's laughing. Anna Paulina's laughing.
Yeah, no,
Okay.
usually if things are kind of at that level, usually it needs a judge to kind of remind everyone to behave better and not to talk to each other that way.
Yeah.
Usually us going out in the hall is not going to help. It might actually make it a little worse. So,
Okay.
yeah.
Fair enough. Fair enough. So let's look at the next. Do I have the slide with the opposing party using a vulgarity? Can we jump to that
Get to
one
that one? Sure.
and then come back? Yeah, let's jump to that because Suzanne sort of touched on that. What do you do when you're attending? Now, in this scenario, it's a mediation, which is still a formal proceeding. And Ann Begler, I know, was here earlier. She'll tell us all about that. Opposing counsel's client calls you and your client a vulgar name. So that's a little different because, the opposing party really should not be addressing you. And who should control that party? I think I kind of buried the lead there by asking that question, but let's get thoughts on that.
I mean, I rarely have mediation or depositions, but if somebody's witness or client is saying inappropriate things to me and or my client, I will usually remind the attorney that they need to get their client under control. And if they need to leave the room to do that, they should. I have a funny story, though, where a witness did go after me in a hallway, and my client was not a person to be messed with and immediately jumped into my protection, which I reminded her I did not need the protection, that I would have taken out the witness if they were going to attack me from behind. But the DA and the police intervened and was like, you need to not do that. And she could charge you if she wanted to. And they handled it very well. But the way we all entered the courtroom at that location changed after that moment. But yeah, no, I always remind people that their witness or client or whatever needs to behave and act appropriately, and we're not here to call each other names. Right. But that's, 30 years of experience and brushing it off the shoulders now. Originally, it did annoy me, but I generally would bite my tongue and hold myself in control.
Thank you, Suzanne. Other thoughts?
I would just, I think it's important.
Thank you, Anne. I was going to call on you. I was going to put you on the spot.
I think that is there's not just one way, but a way a mediator can be really helpful. Sometimes it might just be, I want to talk to Jack for a minute. Jack, it's clear that you're really upset. Can you talk to me? Tell me what's happening for you. Or if it doesn't get taken care of with some brevity, then it might be, I think this would be a really good time for me to just talk separately with Jack and his counsel, and then I'll have a caucus with the other side. So there are lots of things a mediator can do to both give room for voice that's important for somebody to feel he or she has, and at the same time, not to escalate a conflict. So that's my comment.
Thank you very much. Yeah. Anna Paulina, I am so sorry. We're at 12:56. We have 4 minutes left.
I think we're having great conversation. So I will just keep moving the presentation really quickly.
Okay. Should we jump back? Do you want to jump back? Do we have time to jump back to the false statement scenario?
Yes, because I think we're getting more out of the hypothetical. Is that okay?
Oh, absolutely. Absolutely. This one is an excellent slide, and that's why I wanted to save it and take it out of order. You're at a hearing. Opposing counsel makes a statement that is false. So let's all put on our rules of professional conduct hats. How do you handle this situation? And since we now have only 3 minutes, I am going to let everyone jump in and hopefully get some answers here. What do we think? Do we still have Victoria? I'll put Victoria on the spot. That might be the quickest way.
Yeah, I think it's an interesting question because it doesn't say that the person who made the false statement knows it's false. Obviously, if you as the lawyer know you made a materially false statement, you've got to take reasonable remedial measures. I think this might fall under one of these provisions under Rule 3.3. And it says that a lawyer who represents a client in an adjudicative proceeding and who knows that a person, which can be opposing counsel, intends to engage, is engaging, or has engaged in criminal or fraudulent conduct related to the proceeding, you've got to take reasonable remedial measures. That's purely rule-based. Civilly, I don't know. I mean, do you talk to them in private? I don't know.
That's a tough one. And is that a good way to sort of close out our session with the question? Because that is a good question. Thank you, Victoria, very much, because knowing the rules, even if we don't know the answer, we know that we are looking in the right direction for the answer, and hopefully that can lead us to it.
And you obviously don't want to affirm a materially false statement, right? Right.
So can we ask for a brief recess and try to, do we have an obligation? Where do we go from there in terms of fulfilling our duties under the rules of professional conduct? Because we've now gone beyond the intersection of the rules of professional conduct and the Code of Civility. And I think we're now clearly in the realm of how do we best comply with the rules? So do we want to leave it there, lady? Anna Paulina, Dana, what do you think? Victoria, if you have more to say on that, I didn't mean to cut you off.
Well, I think, and Ann Begler, you can chime in, she's on the ethics committee as well. I think the main point is we don't want the tribunal to be misled. So the first question is the statement that opposing counsel made, is it material? Okay, and do you know that it's false? If the answer to those two questions is yes, I believe you are under an affirmative obligation to take reasonable remedial measures.
Thank you.
Agree. Mm-hmm. I agree with that. I think at that point, it is our responsibility to do something.
Mm-hmm.
And even if it's so egregious, even contact the disciplinary board as well, and report the opposing counsel.
So that
is 1 o'clock.
And that's quite an end. Thank you, Victoria. Thank you so much for all of your insight is just incredible. Please, everyone, keep the ethics hotline. Keep that phone number close by. Anna Paulina and Dana, Anna Paulina, I'll let you close it out. Thank you for giving me the opportunity to be with you today, though. I appreciate it.
Thank you to everyone for joining us. Thank you, Anne, for being such a great speaker as always. And thank you, Dana, for coming up with the idea for this topic. Thank you for everyone for joining us. And I hope that you can join the PBA Government Lawyers Committee and the Committee on Civility. Thank you.